Okay. Good morning. We're ready in the main jail? There he is.
Can't hear me.
Okay, what's off that we need to turn on?
Speakers.
Hello.
Can you hear me now? Can you hear me now?
Yes, just as well
beautiful.
as that commercial.
Good morning, Judge.
Good morning. Okay. We have a lot of people on this docket. So we'll start with Mirta Zamora.
She's here present, Judge at Maine. Come on up, Mrs. Zamora.
What's this? Okay, Ms. Zamora, you're charged with domestic violence battery. I find probable cause. Do you have any priors, or is this just the first time that I need to know about?
I believe her priors just involve traffic priors.
Okay.
Yes. She had a DUI, but just traffic stuff.
Okay, so I'm going to set a bond of $1,000 and order no contact with the alleged victim.
Judge, my only request is the following. She's a stay-at-home mom. She's the person that takes care of their 4 children. Right now, the children are with her husband, but her husband does work. So I'd ask you, for purposes of arranging as far as the drop-off and pick-up of her kids to take care of them, I'd ask you limited contact for that exclusive person, for that reason, through a third party.
Limited contact, explain that.
Meaning that they would have to go through a mutual person, either his family or her family, to arrange where the kids would go during the day, so then basically her husband could continue working, pay the bills, so then that their family wouldn't be forced into a situation where they're homeless.
And they're going to do that by how?
Through a third person. So they don't have contact with each other, but through a third person, that person could go ahead and pick up the children and take them back and forth and things of that nature.
Okay. Is Ms. Zamora is in agreement with that?
Yes.
Yes,
Okay.
Judge.
All right.
Well, I mean, she would like full contact, but Your Honor ordered no contact, so that's why I'm asking for that exception.
That's fine. We'll do that exception.
Thank you, Judge.
Your Honor, the jail has requested one case be called out of turn. It's on page 18 of the court's docket. It's Christopher Seymour.
Mr. Seymour is here present, Judge.
Can you find it?
It
I know
would
when you
be
say that,
just a few from the end.
A few from the end. A few.
If you're counting
From the
backwards, it would be Mort, Murray,
Got it.
Fiston, Abel.
Got it. Okay.
Mr. Seymour is here at Maine, Judge.
Okay, Mr. Seymour has a list. Good morning. We have aggravated battery on an officer, 2 counts of possession of weapon or ammunition by a convicted Florida felon, burglary of a dwelling or structure, armed, and criminal mischief over $1,000. And I find probable cause on all counts. Anything else?
Your Honor, on the count 5, the armed burglary, I would be it's a punishable by life offense. I'd be seeking a no bond hold on a finding of proof evident or presumption great for first appearance purposes only. The evidence being that he was seen in the home by the homeowner with the backpack that he was later caught with soon thereafter by law enforcement that had the firearm in it, and he admitted to ownership of the possessing the backpacks, claiming he found it in the home.
Anybody have anything else to say?
Yes, Your Honor, we'd object to the court making a finding of proof evident presumption great, as that is the highest standard of proof under our criminal justice system. The court has only been presented with a probable cause affidavit, which we would argue is insufficient to establish that very highest standard. We would ask the court to set bond for Mr. Seymour in this case. We don't know what was in that backpack when he left the residence, whether the gun was put into the backpack later on. It might be enough for probable cause, and it is, but it is not enough for proof evident presumption great, and we would ask the court to set bond. In addition, if the court does find that proof evident presumption great, this court still has the option to exercise its discretion and set bond for Mr. Seymour anyway. We would ask the court to do exactly that.
Okay. Thank you. The court finds for purposes of the first appearance, proof evident, presumption great, shall leave it at no bond. Thank you.
And Your Honor,
Judge,
bond has
he's
to
still
be...
entitled to bond on counts 1, 2, 3, and 4. I know he's being held no bond, so he's not getting out anyway, but I just ask you to take into consideration, unfortunately, he's homeless and he's indigent, Judge.
Okay, on the aggravated battery, it's going to be $10,000. On the battery, it'll be $1,000. Possession of weapon, $1,000 each count. And burglary will be $5,000.
Your Honor, that was the... that's the...
I'm sorry. I'm in a bit of pain this morning.
And one last request, Judge, a photo order. Can we have an order to photograph his injuries that he sustained?
Sure.
Thank you, Judge.
Nancy Inez?
That would be North Broward, I believe, Judge.
North Broward, anybody home?
Yeah, I don't know why they didn't bring her down for me to speak to, Judge. I don't know if she's a medical reset.
Your Honor, can you give us time to call her down? She hasn't made it down here yet.
Sure.
Okay, thank you.
You're welcome. Marquita Smart?
She's here at Maine, Judge, and she's approaching the podium.
Your Honor, if I could be heard before the court makes a probable cause determination.
Okay, can I just read what it is?
Yeah, I just wanted to...
Okay. Marquita Smart is charged with battery, domestic violence, and domestic violence injunction violation. Counsel?
Your Honor, thank you. There should be no PC for count 2. I don't know if the information the officer had was entered incorrectly, but there is no injunction, or there's a no, in full candor, the alleged victim in this case was previously arrested for a battery against Ms. Smart, and the court ordered a no contact order, ordered him to have no contact with Ms. Smart, yes.
Okay. All right, so we'll find probable cause as to count 1, but not 2. Thank you, counsel.
Sure.
Anybody else have anything they want to say?
Judge, from what my understanding, she's 34 years old. She's been residing in our community her whole entire life. I do not believe she has any priors. The state is going to go ahead and confirm that. Right now, she's a single mother of 4 children. She hasn't worked for 2 months. Her baby was just born. The baby's 4 weeks old. Now she's looking for employment. Judge, I believe the alleged father was helping her as far as financially. At this time, Judge, we'd be asking you, if the state can confirm no priors, we'd be asking you to consider a straight ROR on her behalf.
Your Honor, she has no criminal history. My concern is by my count, 5 different women in the past have sought injunctions, orders of protection, or injunctions against stalking violence, one of which is actually currently pending right now against Ms. Smart.
Against Ms. Smart?
Yes.
I'll set a bond less than I was thinking of doing at $500 in order no victim contact.
Your Honor, if you would like to recall Ms. Ennis, I have an update on her situation.
Sure.
I'm advised by North Broward Detention Center that she is downtown or en route to downtown.
Okay, we'll just put it at the bottom of the pile.
Okay, that's fine.
Let's see what happens. Thank you. Vanessa Nass?
I believe Paul Ryan.
She's also on her route to downtown.
Bottom of the pile.
Yes, ma'am.
Okay. Victor Filpo?
Mr. Filmo is here. Good morning, Your Honor.
Good morning. Sir, you're charged with battery domestic violence. I find probable cause. Anybody else want to tell me something?
Your Honor, Mr. Filpo's criminal history includes 2009 attempted burglary of a structure and grand theft. In 2008, he was convicted of battery. was domestic in nature against a different alleged victim. He had,
When he was convicted, it wasn't alleged.
different victim. That is correct, Judge. Those are the only significant priors he has.
Okay. Anybody else?
Yes, Judge, I do understand that Mr. Popo does have priors. Having said that, he's working. He works in maintenance department, making about $13 an hour. He does have a place separate and apart to live, apart from the alleged victim. He'll be staying with his family who live in West Park. Judge, I'd be asking you to consider setting a bond, considering his priors of $2,500 on this misdemeanor offense.
Okay, 2,500 it is. Thank you.
Thank you, Judge.
Cleoman Pierre?
Your Honor, or no contact on that?
Yes, and no contact with the alleged
Oh,
victim.
no contact, sir. Sorry? No contact. Oh, do you have your property there? Yeah. Judge, the only thing I'm going to be asking is, could you sign an order allowing him to retrieve his property accompanied with law enforcement one time, Judge?
Sure.
Thank you, Judge.
Who? Medical reset? Okay. Kenyona Gaskin.
That's medical reset as well.
LaShawn Williams.
He's present. Good morning, Your Honor.
Good morning, Mr. Williams. You're also charged with battery, domestic violence. Find probable cause. And who wants to tell me what? 2000, you gotta speak up louder.
She was advising me, Your Honor.
Oh.
He was arrested for domestic violence battery in 2011. That was dropped.
Okay.
Judge, I'm going to be asking you to set a $1,000 bond on Mr. Williams' behalf. At this time, he's 29 years old, been here his whole life. He's working. He works at Home Depot, been there for about 2.5 years, making $12.50 an hour. Him and the alleged victim do not reside together. He lives with his father. That's who he's going to be contacting to help post his bond. So, Judge, I'd ask you for a $1,000 bond on Mr. Williams' behalf, considering he has no prior adjudications.
I don't know. Punching with closed fists.
Also know, Your Honor, that
Intoxicated.
the 3-month-old child was present when this occurred.
Oh, thank God it wasn't 3 years. I'm going to set a bond of $2,500.
Yes, sir.
And order no contact. Erica Argote.
North Broward, I believe, Judge.
Miss Argote, you have an out-of-state hold on a felony case that is from California. The bond is $50,000. Are we going to have hearings on this later?
We do have extradition hearings Tuesdays and Thursday afternoons. I don't know if Ms. Argote is on that docket this afternoon.
Okay.
She might be coming in on Thursday.
Highly unlikely she will be on this afternoon's docket.
Yeah,
So
that is
probably
highly
the
unlikely.
Thursday docket that you'll be on for an extradition hearing.
Okay.
Okay? All right. Thank you very much.
Okay.
Dax Murray.
Mr. Murray is approaching, Judge.
Mr. Murray also has an out-of-state hold on a felony violation of probation from, says Cook County. Illinois. Right, Chicago, Cook County. So he probably will also have a hearing either today or Thursday, most probably Thursday, from what I'm being advised, and there's no bond.
Okay. Good luck, sir.
All right, thank you.
Mr. Finley, you're going to be next.
Scott Finley.
He's here at me.
Can you give me 2 minutes to explain?
Hold on one moment, Judge.
Nothing to explain. Let me guess. It's all misunderstood.
Thank you, Judge.
Sorry, Your Honor.
Not a problem. I'm not going anywhere. Be here all day. Okay, so we have an out-of-state hold on a felony case. There's no bond, and it is out of Las Vegas, Nevada. And you will have an extradition hearing either this afternoon or more probably Thursday afternoon. Hey, Jennifer Alquist.
She's here, main judge.
Oh.
Your Honor, she's interested in resolving it. The state's offered me a withhold.
What's the charge?
Expired DL, more than 6 months.
Any chance of her getting it in 90 days and then you make it go away?
That's always a possibility. I have no problem with an ROR if that's what she wants.
Okay.
I think we overheard what was going on. She's awaiting a BARC program. I'm going to ask her if she wants to resolve it or if she wants an ROR. I believe her scheduled date to be picked up from BARC is coming up soon. Let me ask her, Judge.
Okay.
Judge, she wishes to resolve it.
Okay, so the offer is withholding court costs?
Yes.
Okay, well, let me figure this out. How is she getting to BARC? Is there...
I believe it's probably custody to custody. She's awaiting placement. Her expected date as far as the bed availability from what she advised me is June 29th, so the program would come and pick her up.
Who's she in front of that she got that?
Which judge ordered you to BARC?
Judge Tobin Singer.
Okay.
Transportation was already by BARC for us to...
What?
Transportation was already made by BARC for BSO to transport her.
Okay.
And then the KP is popped up. So we'll re-notify BARC if she becomes ready and they'll just reschedule.
Okay, we can do that right now. So the offer on the expired tag is a withhold in court costs. And we'll put the court costs payable in, make it 180 days. Huh? Yes. Okay. So, Ms. Alquist, you understand what the offer is?
Yes.
Okay. And you're entering a plea of no contest?
Yes, ma'am.
Okay, so via withhold, which is the minimums, and I'm putting off court costs for 180 days. So right now, just worry about you getting to BARC and getting better, okay?
Thank you, ma'am.
Thank you. Kimberly Kaczynski?
North Broward.
Good morning, Judge. How are you?
All right. Let's see. We have 2 counts of possession of paraphernalia, well, 2 cases, and 1 of trespass on private property.
Good morning, Judge.
Good morning.
Jara McLawrence. I'd represent Ms. Kaczynski on the City of Fort Lauderdale municipal ordinance cases.
Yes.
Those are counts 1 and 3, I believe.
Yes.
And Judge, I spoke with her this morning. Ms. Kaczynski, as you see, she's in North Broward. She's currently in the detox unit over there at North Broward. She wanted to know if she could resolve her cases and to be released on Friday so she could continue going through detox.
What about her going into drug court?
Judge, I believe that she's homeless. She doesn't want to start something and not be able to finish it or not be able to successfully complete it. She would just like to resolve her cases and continue going through the detox program.
Mr. McLawrence, and what do you think the possibility of her being right back here in a week or 2 is going to happen?
Well, Judge, she hasn't been back here in a year. These are both 2017 cases that I would represent her on, and the other matter is a 2016 case.
Let's reset it on Friday and talk to the judge then. If you want her to be released then have the offers made then, because I'm not going to do it now and keep her in the jail.
Okay. All right, Judge, I'll do that.
All right, so reset this on Friday. Yes, I'm finding probable cause. Stacy Tyler?
It's a medical reset, Judge.
Stacy Tyler's a medical reset?
Yes, ma'am.
Okay. I'm holding. Yes. Yes. Yvonne Palmer?
North Broward, Your Honor.
North Broward. I skipped her? Yeah. Oh, okay. Probably stuck to the... Okay, you're Miss Palmer?
Yes, Your Honor.
Okay, ma'am, you're charged with obstruction of the highway. I find probable cause.
Would the court consider resolving this case this morning?
If you want to resolve this case to the minimums, which is a withholding court costs, you can enter a plea of no contest today. Do you understand that?
I do understand. When the police pulled over, I was just sitting under a bridge. I wasn't panhandling. I wasn't in the middle of the street or anything. I was just sitting under the bridge. I don't even know why he arrested me.
Well,
he says that you were holding a handwritten sign soliciting in the roadway and obstructing traffic. I'm not saying that's what happened or didn't happen. I wasn't there. But if you want to resolve the case and get out of jail today, you can enter a plea of no contest. You would not have a conviction on your record.
Okay.
Or if you want to take it to trial, you can do that too.
No, it's okay.
Okay, so you're entering a plea of what?
No contest.
All right, via withholding court costs. Thank you very much, ma'am. You'll be released today.
Thank you.
Stacy Tyler?
She's the medical reset.
Stacy Tyler, medical reset? There we go. Veronica Miller.
Howard.
Thank you. I have a problem with count one. I don't see any money someplace.
One moment.
Okay, Miss Miller, you're charged with grand theft and you have a probation or community control violation.
Yes.
And state, did you find something that I may have missed as far as why it turned into a grand theft?
I'm trying to find her paperwork, Your Honor.
No.
So they're talking about the hotel room, but it doesn't say how much the hotel room was. So I'm not going to find probable cause on count one. State can have time to perfect. A petty theft?
Yeah, I'm fine with that.
I can do that. Okay, petty theft.
Okay.
On count one.
Okay.
And I'll set the bond at $500 on count one, but there's no bond on the probation violation, and your next hearing in division FW for your hearing on that will be on June 25th at 9 o'clock.
Yes, ma'am.
Okay.
Sorry.
That's it.
Thank you.
Bye-bye.
Okay, thank you. Bye.
Joanne Wilson?
Morning, Judge.
Good morning.
Good morning, Your Honor. Ross Wiener on behalf of the state. Agent Parks on behalf of Joanne Wilson.
Joanne Wilson's here, present, Judge?
Thank you.
Oh, that's her private counsel.
Okay. You see everybody?
Yes.
Yeah, he's there.
I'm here, Joanne.
Okay, ma'am, you're charged with failure to stop and remain at an accident involving a death. And there are 4 counts of DUI with damage to person or property of another. Anybody want to say anything?
Your Honor, I'll let counsel go first. Judge, she's 50 on the issue of bond.
Counsel, state your name for the
Andrew
record.
Parks, behalf of Ms. Walsh. Judge, she's 58 years old. I don't think after speaking with Mr. Brown, this has been going back and forth in terms of the investigation for about maybe 6 or 8 months. I think she has one offense in her entire life. She's married.
Mr. Dominic Smith?
She's married, Judge. She lives in Broward. As it relates to the accident itself, again, I've been going back to the state. After, again, a 6 or 8 month investigation, they decided clearly that my client was either contributed to the accident. I understand it has nothing in terms of the relationship charge. Nonetheless, we got a bit of a cold. Again, no causation, no contribution. The issue here is money. It's a serious issue. I have had conversations with both her husband, who works the midnight shift, gets off, I guess, at 2:30 in the morning or what have you. It's very difficult to speak with him, but I know that money is an issue. I'm looking for some kind of combination, Judge, whether it be level 2 and some sort of financial burden. But again, I don't know precisely what they can afford. I just know it's not that much. But in conjunction with that, Judge, I know that she's not going anywhere. In an effort to vouch for my client, I'm relying very specifically on the fact that she is 58, almost 59 years old, and has never, ever been involved in the system once.
Okay, thank you. Yes, sir.
I do have photos of the crash as well as the video I'd like to show, Your Honor. I've already shown counsel the photos.
Okay.
Video of some sort? There's a video, correct. What is the video of? It's the video of the crash. Okay. That'd be great. I don't want to know. Here are the photos. These are the photos of the second crash. And then this is a video of the first crash there. May I, Judge?
Sure.
Thank you. Second, you'll see the car speeding away.
Which car am I in?
That white car, Your Honor. I'll replay.
Which one? I don't know, what red car, the truck, or whatever.
You'll see a white van, that white truck right there.
Uh-huh.
That's the defendant speeding away from the crash scene.
Okay.
Your Honor, as it relates to bond, the court has to consider certain factors under Florida Statute 903.046. One of those is the nature and circumstances of the offense charged, and that consists of that this crash occurred on November 26, 2017 at 1:51 p.m. The defendant was traveling west on Peters Road. The victim turned into her vehicle, making a U-turn. The victim was ejected and was later pronounced dead on scene. The defendant, knowing that she was involved in a crash, fled the scene in her vehicle west over the turnpike. She was followed by 2 vehicles. One of the vehicles stated that she came to a complete stop at the top of the median, then continued accelerating down the median. One of those vehicles tried to cut the defendant off from continuing to flee. As a result, the defendant made a sharp left turn into South Plantation High School, drove through the fence and into an electrical box. The defendant was confronted by officers. Her speech was slurred. She was unsteady on her feet. She lost her balance. She stated that she takes 1 milligram of Xanax 3 times daily, as well as Ambien. 90 minutes after the crash, her blood was drawn. Her blood alcohol level was 0.23, almost 3 times the legal limit. It also revealed Xanax and Ambien in her system. They also found an empty bottle of alcohol on scene. Mr. Parks is correct as far as there is no criminal history. There's just 3 speeding tickets from 99, 2006, and 2013. But based on the circumstances, the nature and circumstances of the offense, as well as the weight of evidence against the defendant, the state is seeking for the court on count 1 to set a bond in the amount of $80,000. Special conditions of that bond: that the defendant not consume any drugs or alcohol, that she be subjected to random testing once per week, that she be placed on a pre-trial level 1 with a TAD monitor as well as a GPS, that the court ordered the defendant not to drive or get behind the wheel of any vehicle, that the defendant surrender any passport in her possession and not apply for a new, and prior to release and not apply for a new one, and the defendant not leave Broward County. As to counts 2, 3, 4, and 5, the state's asking the court to set bond at $5,000 each for a total bond of $100,000.
Judge?
Mm-hmm.
I know you're ready, I apologize. Just as it relates, and I know it was said, but I don't think it was stated clearly. In the state's effort to talk about blood alcohol level, in the state's effort to talk about pills, there is a misdemeanor DUI charge. Not a property damage charge, a misdemeanor DUI charge. Because in the end, and by the way, there's a bond on that, of course, I think $1,000. In the end, again, there is absolutely, positively, not only no evidence, the state has completely concluded, the police have concluded after 8 months, that my client had nothing to do with the accident in terms of the causation or contribution to the accident. So I'm not quite certain, other than to perhaps inflame what took place. But again, my client, as you saw from that video, and I know it's difficult to see, Judge, off in the distance, but my client is going straight. My client has the right of way. Another individual, sadly, makes an improper turn into my client. My client does not in any way, shape, or form cause this accident. So as it relates to what's in her system, it's a misdemeanor. That portion of it is a misdemeanor. The issue here, Judge, is ultimately whether or not my client left the scene. Certainly it will be litigated, but as it relates to the reasonableness of the bond, Judge, I can be very clear and tell you after speaking with my client, because I did in fact have some conversations via both phone and email with Mr. Weiner, that I can't even imagine on this God's green earth, after speaking with the husband, that he's going to be able to come up with $10,000 for the monetary portion of the bond of the bondsman. Certainly, I would hope, Judge, it would be somewhere in the neighborhood of about $40,000 or $50,000. Certainly, with the special condition of a monitor, level 2. I don't know. I didn't hear all of the special conditions that they were looking for. She has no desire to leave the county, so I don't think that that's going to be an issue, Judge. As it relates to driving, I don't believe that's going to be an issue as well. But again, I just want this to be clear. I appreciate and have dealt with Mr. Weiner many times, his vigor in this, but as I'm sure he'll look right at you and judge and tell you, yes, he's mentioned alcohol, yes, he's mentioned medication. No, none of it has anything to do with why we're here today, because there is a bond on that particular charge. And as upsetting as it may seem in terms of what the potential could have been in the realm of anything being potential, in this particular case, it played no role in the outcome of this particular accident.
Thank you. Anything else?
Nothing to the state, Your Honor.
How did you get your copy? That other copy was so bad. It was black line over it.
Okay, having heard both of you in regard to the bond, I find probable cause onto all counts. The bond on count 1 is going to be $50,000, and on 2, 3, 4, and 5, it's $2,500 each. I'm going to agree with the state on the other conditions that the TAD monitor,
Would you like me to read them again, Your Honor?
no, I had a question
Yes.
between level 1 and level 2.
Level 1, she can't work or go to school. She's on total lockdown. She can still go to court. She can still see her lawyer. She can still go to the doctor.
Is she working?
Judge, the one thing that she does do in having conversations with her, I know she has a sponsor. I know she attends classes regularly. So.
No, does she work was the question. Okay, ma'am, are you employed?
No.
Okay. So level 1 monitor, she can go, you were going to say something? Okay, turn that thing off again, I can't hear it. I'm sorry?
She can leave for medical emergencies. If she has a doctor's appointment, it needs to be pre-approved.
There are a number of those, Judge. I hate to interrupt, I'm so sorry, but I do know in speaking with her yesterday, there are a number of those. That's one of the reasons why I'm asking for two. She's
And
not
though
looking
she
to
may
leave
have
the
a number of them, pardon me for interrupting, she will just have to give the schedule of when she's going to the doctor's pre-trial.
Okay, well, that shouldn't be a problem.
Judge, will she be able to attend AA?
Maybe we should just make it level 2. Level 2 allows her to do what?
Just go to work or go to school. I mean, AA is not work, so I don't see why she couldn't go on level 1 if the court entered an order. But it's up to the court. It's whatever the court wants to do.
If the court wants to put level 1 and then we write a special condition.
Let's do that. Level 1 with special conditions.
She's permitted to attend her AA meetings. She needs to still let them know when she's going to AA.
Okay, and she needs to let them know when she's going to the doctor as well.
Yes.
No driving, surrender the passport, not apply for a new passport, not leave Broward County except for medical reasons. If she has a doctor outside of Broward, that's fine.
Yes, ma'am.
What else was there? No drugs or alcohol, and where is she going to go for random testing? Pre-trial? Okay.
With the TAD monitor?
He also said a weekly testing, I believe. Is that what we're doing for weekly drugs?
I'm going to order minimum weekly testing.
Will be permitted to continue. I believe I heard the state say she takes
I was going to say, Judge, for those medications that are not currently prescribed, correct?
I have no issue if she wants to.
She has prescription medication.
She doesn't drive on them.
Well, she's ordered not to drive, period. Yes, she will have to bring the prescriptions that are current to pretrial, so they can verify them.
Yes, Judge.
Did I miss anything? And the TAD monitor, we have that. Okay. I'm putting something else on there. There is to be no alcohol in her residence at all. So if her husband wants to have a drink, he's got to go visit some friend. None in the house, not even O'Doul's. Okay, does that cover the bases?
Yes,
All right, thank you very much.
Judge, thank you.
Thank you. Yes, ma'am. Pete Peterman.
He's in the Conte facility, Judge.
Not having 1 through 12,
Judge, he has somewhere in the area of $15,000 worth of bond on those other charges. He's asking for an ROR on counts 13 and 14.
Okay. State, any objection to that?
1 moment. I just want to see with the other. Your Honor, frankly, just so the court's aware, some of the other charges he's being held on are illegal credit card use, fraudulent use of ID without consent of a victim over the age of 60, burglary of a conveyance. Frankly, I think these should be higher bonds, but I think it's reasonable to keep the $100 bonds in place.
Okay, well, I find probable causes to counts 13 and 14, which are unlawful possession of personal ID of another, and I'll leave the bonds as is, $100 each. Thank you.
Good luck, Mr. Peterman.
Thank you.
Cedric Hutchins?
Mr. Hutchins is here at Main, Judge. He is approaching, and he declined the services of public defender.
Okay, do we have a driving record for Mr. Hutchins? Good morning, sir.
Hello, good morning.
Do you have a driving record?
Sign for your house, city, state, zip code, phone number.
Thank you. Okay, what do we got? Okay, Mr. Hutchins, you're charged with there's a capias for a charge of driving with a suspended license. Looking at your driving record, it shows a suspended license for a failure to have auto insurance, and apparently your license has expired. So until that clears up, your license and privilege to drive has been suspended. On the other hand, you also have a writ of arrest and commitment issued by, I can't see which, Judge Feinstock for failure to pay your child support. You have a purge amount of $594.82, which is payable to Broward County Support Payment Unit in the form of money order, cashier's check, or cash. If that's not paid, you will stay in the Broward County Jail up to 179 days. You will be brought to Judge Feinstock for another hearing in regard to that. Otherwise, you can pay that purge amount and be released. As far as your suspended license charge, if you want to plea that out, the court would offer you a withholding court costs. However, if you can get it reinstated within 90 days, the state may dismiss it. So what do you want to do, sir?
I have to wait. I guess I have to wait to pay.
Okay, I didn't know everybody knew.
Okay, so your bond on count one is $500 and your purge amount is, as I told you before. Good luck, sir.
Yes. Thank you.
Jamal Bishop?
Mr. Bishop is here, present judge at Maine, and he did decline the services of public defender.
Hey, good morning.
Good morning.
All right, sir, you're charged with assault and trespass. I find probable causes to both counts. I'm going to set your bond at $100 each.
And Your Honor, I just asked, based on the nature of the offense, no return to 101 Northwest 1st Avenue in Fort Lauderdale.
Okay. Thank you.
Thank you, Judge.
Rudely DeRosiers.
Mr. DeRozier is here at Maine, judge. He's approaching.
Sir, you're charged with driving under the influence of alcohol or drugs and obstructing traffic. Your bond is posted. $500 has been posted.
Your
Thank
bond's
you.
been posted, sir. Okay, good luck. You'll get a notice in the mail. All right.
Phillips Gomez.
Mr. Philip Gomez is approaching.
Hey, Mr. Gomez is also charged with trespass. I find probable cause. If you want to enter a plea of guilty or no contest to these charges,
He does, judge.
it'll be a withholding court costs. The problem, as I see it, is one of the store owners is very nice to him and offers him payment for services in his store. So you got to tell Mr. Gomez he can stay in that person's store, but he can't be outside the property.
He understands, judge.
Okay, so do you want to enter a plea of guilty or no contest to these charges, sir?
No contest.
Okay, be withholding court costs. So you understand you can go in that one person's store, but you can't be outside. You got that?
Yes, ma'am.
Otherwise, you and I are going to see each other again.
Thank you.
All right, take care. Navardo Walker.
Mr. Walker, come on up, please.
Morning, Ms.
Good morning, Mr. Walker. How are you?
I'm doing okay.
Well, you left me in drug court.
No, I didn't leave you there, no. I was doing a job in Naples and I meet in a car accident up in Naples. I was in the hospital and right now I'm doing chiropractic. I came down to Florida like about 2.5 weeks ago.
You came back from where?
From Naples.
So
what do you want to Walmart.
What do you want to do about drug court?
If I could have one moment, Judge, to talk to him.
Yes.
Judge, he says he advised me that he still wishes to be in the program. He's looking forward to completing it, but we'd be asking you at this time, since these are your case, to consider releasing him ROR. You did hear, I don't think it was willful, but Judge, he still wants to continue in drug court.
Well, it may not have been willful, but Mr. Walker and I know that we talk about being responsible, right? And Mr. Walker should have picked up the phone and called his case manager and advised his case manager what's going on, and he did not do that. So,
maybe these 2 days in custody hopefully woke Mr. Walker up, and now he's going to basically be there and call his case manager if anything comes up in the future.
okay, where are you residing now? Is that on the where you were in Fort Lauderdale at 3940?
Yeah, 3940. Yeah, that's correct.
Okay, so I'm going to ROR him. We'll reset it 626 at 1:30. If you don't show up then, you're not going to have problem.
Judge, let me write that down for him so he doesn't forget. Can you give me a post-it so I can write this down? Okay. It's going to be June 26th at 1:30 p.m. You know
Is that
Judge
Tuesday?
Zeller's courtroom, okay? Okay, so be there June 26th.
626
at 1:30 p.m. Good luck,
Tuesday
Steve.
at 1:30.
Don't miss. Good luck, sir.
Okay, thank you. Andre Knudsen?
Mr. Hudson, come on up, please.
Yes, ma'am.
Okay, this is a KPS for
Obstruction of traffic, maybe, I believe, probably panhandling, Judge. He wishes to try and ask the court if you would consider resolving this case.
Yeah, you got a while to go. You got a while to go.
Okay, if you want to enter a plea of guilty or no contest, it'd be a withholding court costs. Okay, good luck, sir.
No contest.
Thank you. Be a withholding court costs.
I'm out of here.
Yes, sir.
Thank you.
Good luck, sir.
Thank you.
Ruben Gutierrez.
Mr. Morning, Judge.
Good morning. Mr. Gutierrez, you're charged with resisting an officer without violence and reckless driving. I find probable cause. Your bond on count 1 is 100. Your bond I'm setting on count 2 is 500.
Yes, Judge.
Asada Webb?
Mr. Webb is here present, Judge.
Okay, Mr. Webb is charged with battery. I find probable cause.
Mr. Webb is currently being supervised by pretrial services. He was placed on pretrial on May 10, 2018 in a 1992 case, 92-1533 CF10A, 1 count of aggravated battery and 1 count of simple battery. Based on this court's final probable cause, we're going to ask that his pretrial status be revoked at this time.
Judge,
Yeah.
We're going to be asking you at this time not to take any action. I mean, if I heard correctly, I believe they said 1992 case.
You heard correctly.
Okay, so I did hear correctly. He's 55 years old, been here in South Florida his whole life. At this time, he's not working. He's in the process of applying to disability. He lives in Carroll City with his mother. His mother collects disability, so the current standard bond, which is set on the case before you, $1,000, is something that he's not going to be able to afford. I'd ask you to consider placing him on pretrial. Now, I know he was out on pretrial. I'd ask you, if it was standard, I'd ask you to raise the level of supervision, potentially at this time now consider level 2.
But is he still a resident at Henderson?
Well, and that may be the issue. And that's why the benefit, frankly, of revoking his pretrial is getting him in front of Judge Porth, because that's where that case is out of. Clearly, there's mental health issues. I don't know if that has to be revisited, looking at where he has, if sending him back to Henderson or maybe someplace else based on...
Well, sometimes they won't accept them back. So I think Judge Porth needs to hear this.
Exactly. That's why I'm saying he needs to get in front of Judge Porth.
I'm showing this 1992 case as a no information. Battery on a county detention facility.
I believe he was found not guilty by reason of mental insanity, but the point is he was just ordered last month by Judge Porth. Clearly the case is in front of Judge Porth.
Do you show any hearing? Can you check, somebody check Odyssey to see when the last
hearing was? I'm looking at Odyssey right now, Judge, and on 92012 940 CF10A, it states on 7/17/92 a disposition of no information.
And the case I gave was 921533 CF10A.
That case I don't show at all in Odyssey.
Your Honor, I can't tell you that case does exist. It's in my system.
And do you show any hearings lately in that case?
Yes, it is in Odyssey, Your Honor, and he had a reprimand hearing. He has a reprimand hearing scheduled for June 20th and a conditional release review hearing scheduled for July 27th.
Under what name is that case in Odyssey?
Go, why don't you go look in his computer?
I'll go look.
Go back case
Go get some exercise.
As soon as I opened it, it's by...
There you go.
It's a C-file.
Your Honor, he does have a hearing scheduled for tomorrow.
Oh, great.
All right, so he's got a court date?
Tomorrow.
Tomorrow, okay.
All right. So I think we should leave well enough alone and let Judge Porth deal with this.
Okay, so we're going to take no action.
Correct.
Thank you, Your Honor.
Okay. I don't mind lowering the bond to $500. I don't know whose case is this, or it has yet to be assigned.
This is...
Should probably go in front of Judge Porth.
This is assigned, well, I imagine, yes, it might follow, but as of right now, it's assigned to Judge Carpenter-Toy.
Okay.
But certainly, if he has a hearing in front of Judge Porth...
It's a misdemeanor?
This case, yes.
Oh, okay.
And if he has a hearing tomorrow, if he doesn't post his bond, he'll come back for a second look, and whatever Judge Porth, we'll know whatever Judge Porth did tomorrow at that point.
Okay. Can it be recommended to Judge Carpenter-Toy that this case be transferred to Judge Porth?
I can bring it to the ASA assigned to that division's attention.
That would be good. I mean, I transfer misdemeanor cannabis cases if there is mental health component, and he has a felony case, so he'll do both.
I'll make sure the appropriate person in our county court office is aware of this situation.
Wonderful. Thank you. Good luck, sir.
Good luck, sir.
Clayton Potts.
Mr. Potts, come on up.
Hey, Mr. Potts, you're charged with obstruction of the highway. I find probable cause. Your bond is $25.
Judge, Mr. Potts wishes to ask the court if you would consider resolving this case.
Yeah, via withholding court costs in exchange for a plea of no contest.
No contest. You wish to accept the court's offer?
Thank you. Good luck, sir.
Good luck, sir.
Gordon Koish.
Mr. Koish, come on up, please.
Mr. Koish, you're charged with trespassing. I find probable cause. Your bond is $100. If you want to enter a plea of no contest, it'll be withholding court costs and in order not to return to the place of arrest.
Do you wish to accept the court's offer, sir? No. Judge, in speaking to Mr. Koishi, he respectfully declines the court's offer. I believe he's looking forward to his day in court and disputing these allegations. Unfortunately, he's 46 years old and he's not working at this time. He's homeless. He has no way of financially posting bond, or he doesn't know anyone that could post his bond. Considering it's a trespass, Judge, would you consider an ROR on Mr. Koishi's behalf?
No, thank you. Okay, Dwayne Brennan? Yes, the bond will stay. Dwayne Brennan?
Mr. Brennan, come on up, please.
Good morning, Mr. Brennan. You're also charged with obstruction of a highway. I find probable cause. Your bond is $25. Counsel, are you getting exercise or are you on this case?
No, not this case.
Oh, okay. You want to enter a plea of guilty or no contest via withholding court costs.
He wishes to accept the court's offer, Judge.
And you're entering a plea of?
You say it out loud so the judge can. Okay.
Thank you, sir. Good luck. Marvin Vincent. And I have
Mr. Vincent?
I have a
Vincent?
question of what, State?
Sorry?
I still have a question of what?
Well, Your Honor.
Judge, I've been informed he bonded.
The allegation was that he
Yeah.
endeavored to steal property from the mailbox.
There is such a thing?
Your Honor, under theft, it's either stealing or endeavoring to steal. It's essentially an attempted theft is still a theft in Florida.
Okay.
It's kind of a thought crime. You think about doing it.
He thought a little bit more than doing it.
But he bonded out, so.
Okay. Thank you. Learned something new. Bruce, that's why I bring my mail here. Bruce Burden.
Judge, good morning. Jarman McLawrence. I'm here on behalf of Mr. Burden is making his way to the front. I contacted a friend of his and told him that he posted it. So, Mr. Burden, Mr. Gibson did post your bond.
Okay, did you hear that?
Yes, I believe so.
Okay, your bond has been posted.
It has been posted?
Yes. I spoke to Mr. Gibson. He told me it was posted, and the folks here in the courtroom told me, confirmed that it has been posted. So keep in touch with me. I also contacted the City of Fort Lauderdale Prosecutor's Office. So keep in touch with me so I can let you know what's going on.
How do I get in touch with you?
I thought I gave you my business card, no?
No.
Okay. The young lady right there in front of you, she has a business card that she'll give you.
All right, we're going to give her one right now.
Thank you.
Thank you very much.
Judge,
Thank you.
To Mr. Burden's case and also to...
You're talking to yourself, and with all that chatter, I can't hear you.
Judge, I was asking if you would appoint my office to represent Ms. Kaczynski and Mr. Burden as well.
Sure.
Thank you.
Daniel Sobush.
Mr. Sobush, come on up, please.
I can't reach. I keep on stretching my finger and it hurts. No, I got stitches here, and I keep reaching for things and I hurt that. Do you have a driving record for that person? Sobush. Okay, so this is a capias on a driving with suspended license charge. Thank you. And let's see what's going on. Oh, it's been suspended since 2015 for insurance cancellation. And failure to pay child support, failure to pay a fine. You already have one disposition for driving with suspended license. So if you plea this out, that would be strike two.
I did advise him, Judge, if he gets 3 of these within a 5-year time span, DMV could basically declare him a habitual traffic offender.
Not could, they will.
They will. They will. Judge, he knows that, he's aware of that, but he still wishes to ask the court if you would consider resolving his case today.
You understand, sir, that once you get a third, and if you're sitting in your car the keys in your lap, and you're not even driving, but somebody pulls up behind you for whatever reason, you can be charged with a felony, and then you're facing 5 years in state prison. You sure you wouldn't want to see if you can come back with a driver's license and get this resolved in your favor?
Yeah, it's not gonna happen. Child support's not working with me.
Okay, raise your right hand. You swear the testimony you're about to give is the whole truth and nothing but the truth?
That's fine.
State your full name for the record.
Daniel Joseph Sobush.
You're charged with driving with a suspended driver's license. It's a second. Maximum penalty is $1,000 fine and up to 1 year in the Broward County Jail, or both, plus court costs. Minimum is a withholding and court costs. Understanding that pursuant to the record that I'm looking at, it appears to be a second. I can't promise you that it is, because these records aren't always accurate. If you get a third driving with suspended license in any 5-year period, you are facing felony charges and up to 5 years in state prison. Do you understand that?
Sure.
Okay, have you had any drugs, alcohol, or medication in the last 48 hours?
No, ma'am.
And have you been seen by a psychologist or psychiatrist?
No, ma'am.
Do you understand what's going on today?
Yes, ma'am.
And have you asked sufficient questions of the attorney from the Public Defender's Office?
I believe so.
And he explained to you the rights that you're giving up by the plea that you're about to enter? You're giving up.
Yeah.
You're giving up your right to go and have a jury trial and have the state prove the case against you. You understand that? I need a yes or a no. Okay. And how do you wish to plead, sir?
No contents.
Okay, I'll accept your plea. I find it freely and voluntarily given via withholding court costs and credit for time served.
Good luck, sir.
Okay, Robbie Evans.
Mr. Evans is approaching.
Okay, he's also charged with obstruction of the highway. I find probable cause. Your bond is $25. If you want to enter a plea to this, it'd be a withholding court cost.
Your
Credit
Honor.
for time served. What?
It's no contest.
What?
He needs to be advised. He has an open failing to register as a sex offender before Judge Merrigan, and I don't know what effect this plea could have on that case, but he needs to be advised it could.
Uh-oh. Does he have
Hold on 1 second, Judge. Let me talk to him.
Does he have a hearing set before Judge Merrigan?
I'll check to see when his next court date is. He actually, let's say 19. He had a calendar call yesterday, scheduled for jury trial July 31st.
What did calendar call yesterday? He was probably in jail yesterday.
No, he was arrested last night.
So he missed a calendar call?
I don't know.
Oh.
I don't know what happened there. I imagine it went through. I don't know if there was a waiver of appearance because the case is scheduled for jury trial July 31st.
Judge, considering what's going on, I'd ask you at this time to consider releasing Mr. Evans ROR. He's going to be staying with his friend in Fort Lauderdale. He has a trial date coming up. Financially, he advised me his friend nor him can afford to post the $25 bond, and I believe the case before you, it's panhandling. So, Judge, I'd ask you at this time to consider an R on Mr. Evans' behalf. I was sitting on the wall.
Can you tell me whether he has missed any court dates? Does any capiases in that other case?
In that case, one moment, Judge. I don't believe so. I'm showing he posted a $500 bond in November of last year, and I'm not showing any failures to appear since
All right, I'll ROR him on this case.
Thank you, Judge. Appreciate that.
Okay, you're welcome. Javon Edwards.
Mr. Edwards, come on up, please.
Okay, Mr. Edwards is charged with trespass. I find probable cause. His bond is $25. Does he want a plea offer?
Yes, Judge.
Via withholding court costs and an order not to return to the place of arrest.
He wishes to accept the court's offer, Judge.
Okay, and you're entering a plea of?
No contest.
Thank you, sir. Trent Shirley.
I think he's a medical loan, Judge.
Still? Okay. Salvador Baez.
Mr. Baez, come on up, please. He's approaching, Judge.
Thank you. This is an additional charge of a burglary of an unoccupied dwelling.
Correct, Judge.
And I find probable cause.
Judge, my understanding is Mr. Baez has been, I believe, in custody for 2 years now. He has a VOP no bond hold. He has other cases in which he has a $21,000 bond. The PD's office is pointing out his other case, so he's not going anywhere. I would ask you for a $5,000 bond on this count if Your Honor does find probable cause.
Your Honor, he's got a $10,000 bond on an armed burglary of a dwelling, and the probation violation is for another burglary. I'm going to ask for the same $10,000 bond on this burglary of a home.
So this was unarmed?
This was unarmed.
I think it's $7,500. Thank you. Lunt Cooper.
Conti.
Morning, Mr. Cooper. This is a capias for your arrest for making a false insurance claim. Yeah, I missed this, reading this. Okay, I find probable cause, and the bond is $1,000.
That's fine, Judge. He has some no bond holds on the other counts.
Okay, thank you. Thank you, sir. Elliot Murray.
Mr. Murray is here, present Judge of Maine.
Good morning, Your Honor.
Good morning, sir. This is an additional charge of grand theft. I find probable cause. Anything else anybody wants to tell me about the bond or anything else?
Yes, Judge. He was here yesterday, and he was, I believe, charged this not in custody capias. He was released yesterday on pretrial release. I did explain yesterday, unfortunately, Mr. Murray is not in a financial position to post his bond. He's a handyman. He works for a person like repairing AC. He lives in Pompano Beach with his sister. That's where he's going to be residing. I'd ask you on this nonviolent offense to also release him on pretrial release so that he can report to pretrial and also continue working, Judge.
That seems correct, Judge. He's on pretrial release on counts 1 through 6.
State?
He did get pretrial on 1 through 6. He does have a criminal history where he's gone to prison in the past.
Okay, but when did this occur?
This allegedly occurred
So this
March of this year. Not in custody information. Information was filed and the not in custody capias was issued, Your Honor. It was served on him after he was arrested on the new charges yesterday that included possession of cocaine, paraphernalia, and DWLS third or subsequent offense.
The other thing is there's only one count on the face sheet, but there's 2 counts
Yes, Your
on
Honor.
the probable cause affidavit.
Yes, Your Honor. What happened was when the officer prepared the not in custody probable cause affidavit, he believed there was evidence to support 2 counts, 2 different charges. The state, when we filed the information, we only filed the grand theft. We chose not to file on the
So, but for the fact that nobody saw this yesterday, it could have been part of his pretrial package?
It would have been up to the judge yesterday, Judge Davis, to either include it or decide not to.
I think I'll go along with including it.
Thank you, Judge.
Right, that this popped up. Okay, so we're going to add this charge to his pretrial.
And Your Honor, the only other thing I would request is an order of no victim contact on this case, and that would include a Courtney Menza. It's redacted in your paperwork.
Right, okay, so no contact meaning in person, by phone, or by text, by Facebook, or any other electronic means, or even through a third party, no contact.
Yes, ma'am, I understand.
Okay,
Thank you, Judge.
Thank you. Gary Hyde.
Mr. Hyde? Hyde? Oh, is he bonded? Medical reset. Judge, I've been informed Mr. Gary Hyde is a medical reset.
Okay, thank you. Kelson Pierre.
He's approaching, Judge. He's here, me.
Okay, good morning. You have a possession of cocaine and 9 counts of, what is this?
It's a violation of pretrial.
Oh, violation of pretrial. I was wondering, what, it looked like VOP.
Yeah.
Violation of pretrial release. So, who's the, oh, that's the other person. Thank you. Bond on, I find probable cause, the bond on count 1 is $1,000, and there's no bond on the balance of counts.
Thank you, Judge.
Thank you. Dominique Smith.
Mr. Smith?
Hey, sir, you're charged with dealing in stolen property, false ownership information given for pawned items, and there's 3 outstanding capiases, 2 felonies and a misdemeanor. Find probable cause as to all counts. And I can't read this. What's the bond on count 1? Is that $3,500?
Yes, ma'am.
And $1,000 on count 2, and there's $50 on count 5. I don't know what 4 and 5 are.
4 and 5 are felony cases in possession of PDP and possession of
cocaine. This was a no-show arraignment, no bond by Judge Tobin Singer. Okay, so there's no bonds, and I guess he will be brought in front of her at the appropriate time. Okay. Thank you.
Good luck, sir.
Monty Abel.
North Broward.
North Broward, Your Honor.
Thank you. Okay, Mr. Abel, you're charged with possession of THC and trespass. I find probable cause. Your bond is $1,000.
Your Honor, I'm going to ask the court to consider placing Mr. Abel on pretrial release. He's been a resident of Florida since 1959. He has family here. He has a place to stay. He has been working as a carpet cleaner since he was 15 years old. He's self-employed in that capacity. He's been living at the same address for the last 3 years. He has a GED, and I don't think he has an extensive criminal history. I think it's misdemeanors mostly from what he told me.
Your Honor, I can advise you. I've spoken with Sergeant Baker, BSO, who's advised me. This is Mr. Abel's 3rd arrest in about just under a month in the same general area. He's just been a nuisance in the area.
What has he been arrested for?
May 28th, it was a lording or prowling where he was looking into cars, resisting without violence, possession of cannabis and drug paraphernalia.
He used to get into drug court.
June 6th, it was just a possession of cannabis, but there was also allegations that he destroyed property of local businesses, but they didn't want to prosecute.
Mr. Abel, my recommendation to you to get your life straightened out is to enter into drug court. You know, you get a lot of help there. And you'd be able to pay your rent and your light bill and if you're not buying drugs with it.
Your Honor.
Yes, and that's why you're not doing anything else of value. Because your pot's a couch potato drug.
That's true.
It doesn't allow you to get off the couch and accomplish anything. Because you're too busy chilling.
Yes, it's very true.
Okay? I call it the lack of responsibility drug. Don't meet your responsibilities, you don't pay your bills, you don't get to where you got to go on time, and that causes all the other problems.
I'll give it a whirl. They want to run me through drug court, 6 months of it or something. I don't know.
Well, probably be, once it turns into THC and it doesn't look like oregano anymore, it turns into a felony. So it may be more than 6 months, because otherwise you're looking at up to 5 years state prison.
Really?
Yes. Yep. So,
someone gave me that, here, try this, and I'm going to do 5 years or something. Somebody handed me on the street and gave me.
Yeah, look, we got choices we got to make in life, and when we make our choice, we got to deal with the consequences. So, no thank you would have been the other choice. So I'm going to keep your bond at $1,000. Talk to your public defender and request to go to drug court. You can do this. All right, lots of luck to you, sir.
Thank you.
Dakota Fishman.
Mr. Dakota Fishman is approaching.
Thank you. Okay, we've got 2 violations of probations and a capias. Find probable causes to all counts. There's a VOP hearing June 21st at 8:30. Division FB. Status hearing June 25th in MP at 1:30. And what's the other one? The other one's a trespass with a $250. Well, they all have bonds. $5,000. $2,500 and $250. Ooh, carfentanil. Wow. Okay, lots of luck, sir. David Mort.
Mr. Mort is here, main judge. Come on up, sir.
Okay, Mr. Mort has a capias and an out-of-county hold on a felony. Capias here is for petty theft with a $500 bond. And the Dade County case is for possession of cocaine. I'm looking to see if that has a bond. No bond.
Judge, and speaking, Mr. Mort, he wishes to ask the court to consider resolving count number 1. So therefore, once that's resolved, there's no longer any holds, and Dade County is free to pick them up.
What are his priors?
There's felonies from 2013 out of Kentucky where a bench warrant was issued in 2016. I don't know how one way or another those cases were resolved. Other than that, just the pending case in Dade.
Okay, so if he wants to enter a plea to this petty theft case, it would be an adjudication, no fine, credit for time served, and court costs.
He wishes to accept this.
How do you wish
court
to
talk,
plead?
Judge.
How do you wish to plead, sir?
No contest. No contest.
Okay, that's to the petty theft charge. Good luck, sir. Jeffrey Stiller.
Mr. Stiller, come on up, please.
Okay, Mr. Stiller, this is a third or subsequent petty theft. I find probable cause. Your bond is set at $750. It's now turned into a felony. Okay, thank you very much, sir.
Thank you.
Arlindo De Cruz, Jr. Okay, Mr. De Cruz is charged with burglary of an unoccupied. Can you turn that thing off, please? It's so noisy. Or burglary of an unoccupied structure, possession of burglary tools with intent, violation of probation or community control, another count of burglary of unoccupied structure, burglary tools, grand theft, first degree, probation violation, burglary of an unoccupied structure, and I missed page 2. Possession of burglary tools, another probation violation, and an out-of-county hold. Oh, God. That's from Palm Beach. Dealing in stolen property with a $7,500 bond. I find probable cause as to all counts.
Your Honor.
Yeah.
I'm going to be requesting $15,000 bonds on each burglary. The concern being, as the court is aware from these reports, that this appears to be involved in a string of burglaries out of Century Village and storage units, one of which he's accused of stealing over $200,000 worth of sports cards, where most of them are gone now, and does not appear that the victim will ever be able to retrieve them, where he sold them for $200. And as you can see, he's out on felonies, probation out of the state of New York and Palm Beach.
Judge, right now he advised me that he works in construction. His pay varies from day to day. It could be as low as $60, as much as $120, $150. He lives in Coral Springs with his wife and 3 children. His wife is a stay-at-home mother. He's supporting his family. Judge, on these third-degree felonies on counts 1, 4, and 8, I'd be asking you to $5,000 on each count, and that's what the defense is requesting, Judge.
Okay, on 1, 4, and 8, I'm setting $10,000 bond each. The other bonds are counts 2 and, I can't read this, 2 and 5 and 9 are $1,000 each. And then he has the VOPs where there's no bond. I think that takes care of everything.
2 things. One is, Your Honor, keeping the $7,500 bond on 6.
6.
That was the grand theft first degree.
Yes.
And, Your Honor, I'd also ask, at some point, if he should be released, I'd ask for no return to Century Village.
Sure. Century Village, Deerfield?
Yes, ma'am.
Okay, because there's more than one. Thank you.
Yes, sir.
John O'Brien. Mr. O'Brien, you're charged with battery on a officer or firefighter. I find probable cause. So, does he have any related priors?
Just trespasses.
Judge, we're going to be asking you to consider releasing Mr. O'Brien on pretrial release. Right now he's looking for work. He's 40 years old, been here since 1989 in our community. He lives with his mother. His mother works at Lowe's department, Lowe's. So he doesn't think that she can afford very much of a bond, so I'd ask you to consider releasing him on pretrial release.
You know, I would second that, Judge. I think that this is
yes,
pretty poor excuse for a battery on a law enforcement officer. He's accused of throwing a pen at the officer. If an officer feels the need to write up a report for a felony battery Leo because someone throws a pen at them, maybe they should be inclined to find a different line of work.
Well, it could have hit his eye and
It could
caused
have hit
severe
his eye.
damage.
I know. Listen, I know. I understand.
Well, lest we forget that the reason the officer was there to begin with is because he put his hands on an employee of the restaurant who just happened to say they didn't want to prosecute him for the battery.
Which is not what he's charged with. It's a battery on a law enforcement officer. I know, Mr. Linder, I understand that.
As I said, we make choices in life, right? You
You
could have
do,
handed him
and-
the pen. He could have dropped the pen on the ground.
And he apologized.
Yes, well, what does the state want to say about pretrial release?
I'm fine on pretrial, Your Honor. No. Well, it depends how good your aim is. I mean,
You know, life is full of choices. All right, I will order pretrial release. I am telling you, Mr. O'Brien, I am going to order you not to return to the place of arrest. That means not even within 1,000 feet of that place.
Okay, Judge.
Okay, any special terms or conditions?
I'm not requesting anything, Your Honor.
All right, good luck, sir.
Thank you, Judge.
Ronald McGraw. Okay, Mr. Right, there he is.
How you doing?
Oh, Peachy, how are you? Okay, Mr. McGraw, you're charged with grand theft. I find probable cause. Your bond is $1,000. Going to order you not to return to the place of arrest. Anybody else have anything they want to tell me?
Yes, Judge. Unfortunately, when he was arrested, he didn't have his phone with him, so he has no way of contacting anybody to post his monetary bond. So he's unfortunately, because of that, those circumstances, going to be remaining here at the jail.
Well,
so
can't
I'd ask you if
we
this.
order that he be allowed to use a phone?
No, but he doesn't have any phone numbers. So they'll allow him to use the phone, but he has no one to call because he doesn't have phone numbers memorized. And when he was arrested, he didn't have his phone with him to get the contact numbers. So I'd ask you at this time to consider releasing him on pretrial release. He's 57 years old, been here his whole life. He works in landscaping. He does have priors, but I believe he's been out of trouble now for about like 3 or 4 years. I'd ask you to consider pretrial release on this nonviolent offense.
State?
Just to advise the court, he had a grand theft in 2016 with a VOP, a theft in 2016, 2012 grand theft, 42 months state prison as a habitual offender. He was released in 2015. 2011 burglary of a dwelling, 42 months state prison as a habitual offender. 2008 burglary of a structure and theft.
Okay, so the answer to that is I'm not going to allow him out on pretrial.
Yes, Judge.
Thank you. That didn't sound too good. Luis Castillo.
Mr. Castillo is here present, Judge at Maine, and Judge, we'd be waiving formal reading of the charge.
All right, I find probable cause. I'm ordering no contact with the alleged victim, MB, for the record. That means no contact in person or by any electronic means whatsoever or through a third party. And We have to set a bond. I don't know if he has any priors.
I don't see anything. Do pretrial have any notes?
Sorry? No record? State?
Your Honor, based on the circumstances and the allegations, even with no priors, I'd be requesting a $50,000 bond.
Judge, this is one of the most unusual probable cause affidavits I've seen relating to this type of offense. I don't know exactly what happened here or what's ultimately going to be charged, but I think $50,000 is too high a bond under these circumstances. I would ask the court to consider something less, and I'd ask the court to consider whatever Mr. Romero has to say.
Judge, I did speak to Mr. Castillo. He's 33 years old. He's been here almost his whole entire life. As the state said, he has no prior contact with the criminal justice system. He is a registered voter here in Broward County. He's working. He works at the Golden Corral. He's a server. He puts in lots of hours with tips and everything like that. He can make about $600 per week. He lives with his mother. His portion of the rent is about $400. His mom is retired. Right now, that's the person that he's going to be contacting to help post his monetary bond. Also, what he owns a 2011 Camaro. It's beat up. It has about 115,000 miles on it. So he thinks the resale value is about $3,000. He's hoping his mom, with that, can help towards his bond. Judge, considering the allegation, I do understand they're serious. I'm going to be respectfully asking for a $10,000 bond on Mr. Castillo's behalf.
And I'm obviously just noting for the record that according to the probable cause affidavit, there's a recording of the defendant essentially admitting to the allegation to the alleged victim.
Yes, after he removed the cord from around her neck and picked her up and put her in bed as she was trying to kill herself. So I think that there's a lot going on here that we don't know, and I think that the benefit of that should inure to Mr. Castillo. As I say, this is one of the most unusual probable cause affidavits on a case like this that I've seen in my 33 years. And I think Mr. Romero is not being unreasonable in a request for a $10,000 bond.
I read the probable cause affidavit. I will agree with you that it's unusual. That's about all I can agree with. I'm not going to repeat what I thought when I read it. And I will keep the bond at $50,000. If he is released, he shall be placed on electronic monitor level 1. Keith Thorpe.
Mr. Thorpe has family members present, Your Honor.
What's level 1
I'm sorry, Judge.
What?
The only thing, Mr. Castillo, would you consider level 2 with the monitor as opposed to level 1? Because he's working, he helps support his mom. That's the only thing I'm going to be asking for Mr. Castillo's behalf.
State, anything you want to say about that? State?
Yeah, no, I just need to look at something, Your Honor. Your Honor, based on some of the specific allegations, I believe level 1 is appropriate at this time, and obviously he can seek review in front of the assigned judge.
I don't have any problem with him going to work, so I let him go to work.
Then, Your Honor, in a point of caution,
yep,
I would ask that the no contact be 1,000 feet.
You got it.
Thank you, Judge. Mr. Keith Thorpe is here present, Judge Amain.
Okay, 14, 15, 16, 17, 18. All right. Mr. Thorpe, you're charged with a violation of community control, driving with a suspended license, something about headlamps. I find probable cause as to all counts. There's no bond on the probation violation. Is there a hearing to be set on that?
I believe pursuant to administrative order, it's supposed to be, maybe even tomorrow's is.
I didn't see one in Odyssey. I looked earlier. I advised the family it should be within the next few days.
Judge Duffy?
Yes.
Okay, so you'll have a hearing in front of Judge Duffy within the next 2 days. Your license is pursuant to your driving record is presently suspended for 4 outstanding tickets that need to be paid. You already have 1 driving suspended license charge on your record within 5 years, so this would be a second, and while that's pending, I guess you shouldn't plead that out.
Yes, Judge.
Okay, and yes, ma'am, your name?
My name is Catherine Thorpe.
Okay, right now, he's not going anywhere. He should have a hearing in front of the assigned judge in his division, Judge Duffy, within a day or 2. Okay.
Thank you.
Yes, ma'am. Thank you. Ilya, what is this? Tinker.
Conti.
Okay. This is somebody got to help me out here. This is a change of charge to obtaining property over $50,000 by fraud. Is that, yeah?
Your Honor, I mean, this is a change of charge. As you can see on the original findings that Judge Lee signed, it was obtaining property over $50,000 by fraud, first-degree felony. We filed it as an aggravated white-collar crime, which is still a first-degree felony. All I'm asking the court to do is set the original bond that Judge Lee set, the $5,000 bond, and conditions back in place on this 1 count, and he can seek any further modification in front of his assigned judge.
I'm sorry. I got everything except for the last part. Okay. What you handed me was what Judge Lee signed. It showed on this first count an original bond of $25,000.
No, he crossed it out and set it at $5,000.
Okay, and then wrote something about Nebbia hearing. I can't read the rest. GPS.
Pre-trial. Yeah, those were the original release conditions. I'm just asking that those same conditions and same bond be placed back onto this charge. It's a lateral change of charge from one first-degree felony to a different first-degree felony.
So you want the $5,000 on the change of charge that's in front of me now?
Yes, just putting him in the same footing he was after he saw Judge Lee.
Gotcha. Anything else?
No, Your Honor. Mr. Tinker has 130 some odd counts with high bonds on many of them, so.
Okay, all right, Mr. Tinker, so they changed the charge to obtaining property over $50,000 by fraud.
Your Honor, I'm sorry, that's what it was originally. We filed it as aggravated white-collar crime.
So why did they put this on here again?
I don't know. If you look at the booking sheet.
It says change of charge from organized scheme to defraud to, so how should it be?
Aggravated white-collar crime.
Okay. And the bond shall be set at $5,000. Thank you, sir.
With the same original conditions.
With the same conditions as previously set up by Judge Lee.
Thank you,
So
Judge.
everything is the same except for the bond, except for the charge amount. Okay, good luck, sir. Nancy Inez?
Judge, those are the, we have Nancy Inez.
Yeah.
She was North Broward. She hasn't been transported here to Maine yet, so I'd ask you if we could reset this for the afternoon.
You got
Both Nancy Inez and Vanessa Nass.
Okay.
Thank you, Judge.
Okay.
And what time will we be starting this afternoon, Judge?
1, I was told. Do we have extradition?
Extradition.
Do we have extraditions? What?
This, you have to give it back to
Thank
you.
Is everybody in agreement to do it at 1:30? Or you want to?
Just to avoid the confusion that happened last week, because I thought we started our extradition at 1:30, and then Judge Tudor was here at 1 o'clock. I mean, so I need to tell, because we do extradition today, I need to tell.
Do we have extraditions today? Okay.
Usually it starts at 1, the extradition.
And how many of them do we have? Do we?
Deputy.
So how long does that take? Since I don't think I've ever done one in my life. No.
It really all depends on.
Good to know.
And Your Honor, if you want, the ASA that'll be here, he can go through the whole speech with them. And
good.
And honestly, it depends how many want to waive or how many.
All right, let's be here at 1 o'clock and get it, because I may be slow. Not you, me. Okay.
It's right here, Judge.
So I got it, well.